Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. Today is April 22nd, 2021. It's 10:01 a.m. We're here for a hearing in docket number 2020-13-A. Before we begin, please join me in a brief moment of silence. Thank you. Let's take roll. Present in the hearing room, we have Commissioner Caston, Commissioner Thomas, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioners Irvin, Williams, and Powers. Special Counsel Butler, would you please read the docket?
Yes, sir. Thank you very much. Good morning, Mr. Chairman and other members of the Commission. The docket before you today is docket number 2020-13-A, the application of Chem-Nuclear Systems, LLC, for adjustment in the levels of allowable cost for fiscal year 2019 to 2020 and identification of allowable costs for the fiscal year 2020-2021. A hearing has been scheduled for April 22nd, 2021 at 10 a.m. before the Commission for the purpose of receiving testimony and evidence from all interested parties. Mr. Chairman and other members of the Commission, the docket is in order.
Thank you, Special Counsel Butler. Let's take appearances from the parties. Applicant.
Good morning, Mr. Chairman. I'm David Black. I'm with the Next Improvement Law Firm here today representing Chem-Nuclear.
Good morning, Attorney Black. Good to see you again. Interveners and statutory parties, South Carolina Department of Consumer Affairs, South Carolina Department of Health and Environmental Control, Atlantic Compact Commission, South Carolina Attorney General. Obviously, the record reflects that those parties decided not to join us today. Office of Regulatory Staff.
Good morning, Commissioners. My name is Chris Huber, and I'm here on behalf of ORS. I am joined by Andrew Bateman, and I do have one preliminary matter when the Commission is ready to hear it.
Please proceed, Attorney Huber.
Good morning, Mr. Chairman and members of the Commission. The matter before the Commission this morning concerns the application of Chem-Nuclear Systems for an adjustment in the levels of allowable costs for the fiscal year ending June 30th, 2020, and for the identification of allowable costs for the fiscal year ending June 30th, 2021. In accordance with SC Code annotated section 48-46-40, the Office of Regulatory Staff obtained and audited the books and records of Chem-Nuclear. The ORS examination of Chem-Nuclear's application and underlying financial records was conducted by ORS Director of the Audit Department, Daniel Sullivan, or prepared under his direction and supervision. Based on the results of ORS examination, Chem-Nuclear accepted ORS's adjustments and filed an amended application with the Commission on March 2nd, 2021, incorporating ORS's adjustments. Mr. Sullivan's examination report and exhibits were filed with the Commission on March 16th, 2021. Mr. Chairman, I would ask at this time that the cover letter filed by ORS on March 16th, 2021, and Mr. Sullivan's report and exhibits 1 and 2 be marked for identification and entered into the record of this case as a composite hearing exhibit.
ORS's cover letter, Mr. Sullivan's report and testimony, along with, I think, what you identified as exhibits 1 and 2, will be entered into the record as a composite exhibit. That will be hearing exhibit 1.
Thank you, Mr. Chairman. ORS has not filed pre-testimony in this proceeding. However, Mr. Sullivan is present in the virtual hearing room today and is available for questions from the commissioners should the Commission wish to call him to the virtual stand subsequent to the applicant's witness testifying.
Thank you very much.
Thank you.
I'm sorry, is there something else?
No, Mr. Chairman, thank you.
Yes, sir. If there's nothing else, applicant, please call your first witness.
Thank you, Mr. Chairman. Chem-Nuclear calls Mr. Benjamin S. Smith to the stand.
I'm here.
Good morning, Mr. Smith.
Good morning.
Mr. Chairman, do we need to swear the witness?
Yes, the court reporter will swear you in.
I'm not hearing the court reporter.
Give us 1 second.
Can you hear me now?
Yes,
Do you solemnly swear the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Good morning, Mr. Smith.
Good morning.
Please state your full name, position, and business address for the record.
My name is Benjamin S. Smith. My business address is located at 740 Osborne Road, Barnwell, South Carolina. I am employed by Chem-Nuclear Systems, LLC, CNS, a wholly owned subsidiary of Duratec Incorporated, which is in turn a wholly owned subsidiary of EnergySolutions, LLC. As Director, Barnwell Disposal Operations, I am responsible for the safe and proper disposal of low-level radioactive waste received at the disposal facility in accordance with the company's South Carolina radioactive material license. I am also responsible for management, supervision, and administration of disposal operations personnel, equipment, and buildings.
Please state your educational background and professional experience.
I have a Bachelor of Science degree in Geological Engineering from Washington State University, Pullman, Washington, and a Master of Engineering in Civil Engineering from the University of South Carolina. I'm a registered professional engineer in South Carolina and a registered professional geologist in South Carolina. I'm also certified as a groundwater well driller in South Carolina. I have over 30 years of experience at the Barnwell Disposal Facility in various positions, starting as a geotechnical engineer, progressing to senior project engineer involved in design and construction management on the site, regulatory compliance, financial management, and program management for large component projects, phase one decommissioning activities, and other special projects at the disposal site. I have been employed with CNS since 1986 and assumed my present position in August of 2017.
Have you previously provided testimony before the Public Service Commission?
Yes, I have testified before the Public Service Commission 2 times, and last year I submitted written testimony to the Public Service Commission.
What is the purpose of your testimony?
My testimony will provide information to the Commission about the disposal site operations relative to disposal of low-level radioactive waste at the disposal facility located in Barnwell County, South Carolina. I will provide a brief background on the general process that has been used in this proceeding for identifying the allowable costs associated with our low-level radioactive waste disposal business. I have included an amended application for identification of allowable costs as an exhibit to my testimony. My testimony will be based on the amended application instead of the application filed in September of 2020. The amended application, including amended Exhibit A, amended Exhibit B, and amended Exhibit C, reflect the agreed upon changes resulting from the Office of Regulatory Staff's annual audit of our allowable costs. My testimony will also focus on the principal differences in categories of costs between costs we actually incurred in fiscal year 2019-2020 and the estimated costs identified in Commission Order 2020-441. Finally, my testimony will summarize the costs we are requesting the Commission to identify as allowable for fiscal year 2020-2021 as shown in amended Exhibit C.
You are the same Benjamin Smith that prepared 12 pages of direct testimony that was filed with the Commission on March 2nd, 2021?
Yes, I am.
If those same questions were asked today, would your testimony remain the same?
Yes, to the best of my knowledge, my pre-filed direct testimony is true, and my answers to the questions posed would be the same today if given orally from the stand.
At this time, I would respectfully request that the Commission allow Mr. Smith's pre-filed direct testimony to be read into the record as if given orally from the stand.
Mr. Smith's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Chem-Nuclear also requests that its March 2nd, 2021 amended application with attached amended Exhibits A, B, and C, as well as Mr. Smith's direct testimony be entered into the record as I believe it will be hearing Exhibit 2.
Mr. Smith's Exhibit amended Exhibit A, B, and C will be entered into the record as hearing Exhibit number 2.
Thank you, Mr. Chairman. Mr. Smith, have you also prepared a summary of your pre-filed testimony?
Yes, my summary testimony will explain the allowable costs incurred in fiscal year 2019, 2020, and the cost proposed for fiscal years 2020, 2021.
Please describe the allowable costs incurred in fiscal year 2019 to 2020 and compare those costs to the amounts identified in Commission Order 2020-441.
This part of my testimony will focus on the principal differences in categories of costs between actual costs incurred in fiscal year 2019, 2020, and the costs identified in Commission Order number 2020-441. Actual fixed costs are less than the costs identified in Commission Order number 2020-441. So actual fixed costs incurred in fiscal year 2019, 2020 were $2,475 less than the fixed costs identified in Commission Order number 2020-441. Chem-Nuclear proposed no adjustment in the fixed costs in the original application, and in the amended application is shown on amended Exhibit A. Variable costs. Variable costs consist of 2 parts. I will discuss variable labor and non-labor costs, and then variable material costs for the concrete disposal vaults, the variable vault costs. Variable labor and non-labor costs. The actual variable labor and non-labor costs experienced in the disposal of waste in fiscal year 2019, 2020 resulted in a total variable labor and non-labor cost of $146,406.40. The actual variable labor and non-labor costs experienced in fiscal year 2019, 2020 is $53.02 more than the amount that would have been anticipated based on rates provided in Commission Order number 2020-441. Chem-Nuclear requested an adjustment in this category of costs of $53.02 in the original and amended application. Variable material vault costs. The amount of actual variable material vault costs incurred in fiscal year 2019-2020 for standard disposal vaults was $478,625.12. This amount is $33,630.43 more than the amount calculated using rates identified in Commission Order number 2020-441. Chem-Nuclear requests an adjustment of $33,630.43 in this category of costs in the amended application. This is the same amount of adjustment we requested in our original application. Irregular costs. Not all irregular costs for the year are known at the time a commission order is issued. Irregular costs are costs incurred for projects that may not occur each year, or projects that occur each year but with varying costs. Regular cost projects with varying annual costs include trench construction, site engineering and drawing updates, and other site construction projects. Examples of projects that may not recur each year are large component disposal and license renewal proceedings and hearings. Total actual or regular costs incurred for fiscal year 2019-2020 were $1,016,237, compared to the amount identified in Commission Order number 2020-441 of $1,256,031. Therefore, Chem-Nuclear seeks no adjustment in irregular costs shown in the original and amended application.
Please describe the costs proposed for fiscal year 2020 to 2021.
The costs proposed for fiscal year 2020-2021 are summarized in amended Exhibit C. Disposal operations in fiscal year 2020-2021 will continue to reflect smaller routine volume disposal site operations because the disposal site will continue to accept only waste from the 3 Atlantic Compact states. So proposed fixed costs. For fiscal year 2020-2021, we propose $3,078,522 in total fixed costs, as shown on amended Exhibit C in the amended application. The original application proposed $3,215,963 in total fixed costs. As a result of the ORS audit, which reviewed actual costs from July 1 through December 31st, 2020, and projected costs for the remainder of the fiscal year, costs in the labor, fringe, and non-labor category, along with costs in equipment leases and support, in corporate allocation categories were decreased, which resulted in the lower amount proposed in the amended application. Proposed irregular costs. As discussed earlier, not all irregular costs were known at the time the application was submitted. The irregular costs identified in amended Exhibit C are based on projected costs incurred during the first half of fiscal year 2020-2021 and activities expected in the second half of the fiscal year. A total of $508,368 in various irregular project costs was summarized in Exhibit C to our original application. The amended application proposes a total of $577,277 in irregular costs as shown in amended Exhibit C. This increase is primarily due to an increase in the trench characterization and construction equipment repairs. Proposed variable labor and non-labor cost rates. The variable labor and non-labor cost rates proposed for fiscal year 2020-2021 are based on actual experience during fiscal year 2019-2020, then inflated by 2.5%. There is no change in this category of cost from the original to the amended application. Proposed variable material vault cost rates. The vault cost rates proposed in amended Exhibit C are based on actual experience during fiscal year 2019-2020 and then inflated by 2.5%. The amount shown on amended Exhibit C for variable material cost rates, vaults, are the same as those shown on Exhibit C of the original application.
Does that conclude your direct testimony?
Yes, it does.
Thank you, Mr. Smith. Please answer any questions that ORS or the commission may have.
Office of Regulatory Staff.
No questions, Mr. Chairman.
Commissioner questions for this witness.
Mr. Chairman.
Commissioner Thomas.
Thank you. Thank you, Mr. Smith. Appreciate your testimony today. I just have a couple of little questions. You've notified the commission that you're switching to new accounting system and that has been pushed out until at least September of 2021. Just wondering, is that still sound like a reasonable time frame for having this put into operations?
So as it stands now, the timing on that is proposed and has been pushed to September 1st, 2021. But my information is that could be pushed back as far as January 1st of 2022, as reflected in a recent communication. So that's the best update I have on that.
Okay. So do you anticipate that will affect accounting for the next review period?
Yes. I mean, based on that projection that there will be accounting system changes in the next time frame.
And so it'll really, you think everything will end up lining up, but it'll just be a little bit later. Would that be correct?
Yes, that's correct.
And will all of EnergySolutions and its subsidiaries operate under the same new accounting system?
That is my understanding, yes.
Okay. So are you confident that the corporate costs will be properly allocated to all the subsidiaries, including Chem-Nuclear, once the new accounting system is in place?
Yes.
Okay. Thank you. I appreciate that. That's all I had.
Thank you.
Commissioner Caston.
Good morning.
Good morning.
I don't have the information here in front of me, but I remember looking at some of it, I think. And there are ground monitoring wells in place, correct?
Yes, there are.
Is the groundwater just simply being monitored, or is there any mitigation occurring?
At this point in time, it's monitoring is the primary activity. There has been mitigation activities that have occurred over many years, but this time it's simply a monitoring.
But all in compliance with DHEC regulations.
Correct.
And I can't recall, are all the, I guess, the trenches lined and have leachate collection systems? I don't recall. Originally it didn't. Does it now?
The Barnwell facility as a radioactive material management facility does not have a underlying liner system. It uses a multi-layer cap on the top, and then performance assessment forms a basis for compliance. There are collection systems in the base of the trench, but not a aligned system for full collection of any potential water intrusion.
And just a
And
clay seal top?
Clay and polyethylene and bentonite lining systems.
And the vaults, they're not watertight either, as I recall, correct?
Vaults are not designed to exclude water. They're provided structural stability.
Okay. One other thing I noticed somewhere too, where the vaults you order, sometimes you may over order. How are those accounted for, like in the, so they're not double charged?
So they are charged as they are used for disposal.
Okay.
So we need to order sufficient quantity to be able to address, demand. Other than that, they're charged as they're used for actual disposal.
All righty, thank you very much, Mr. Smith.
Thank you.
Good morning, Mr. Smith.
Good morning.
Thank you for appearing before us this morning. You have a wealth of experience and education, and it's always a pleasure for me to get to talk with someone with your resume and pedigree.
Thank you.
I'm going to use my common vernacular to sort of describe the facility, because I really want to wrap my head around the entire process. Now, the facility is called a low-level radioactive waste facility. Is that correct?
Yeah, so low-level radioactive waste management facility, disposal facility.
Okay. And
So,
I'm sorry, go ahead.
so it's primarily focused on the receipt and disposal of waste, not the processing of waste materials.
Right. Okay. And so what happens to that material once you all receive it?
So the process of disposal is the receipt. All receipt occurs by highway. Ultimately, certain components may come by rail, other means, but ultimately it'll enter through the front gate of the facility, at which point it is placed into a receipt category where the compliance is evaluated of the received waste. We would have already received advance information about and allowed the shipments. At that point in time, both Chem-Nuclear Systems and SC DN will perform activities to verify that we may receive that waste. Once that waste is cleared for receipt, it is either staged and or moved into a location where it is prepared for offload. There's a location called a cast maintenance building where it would be received, and typically casts are received at this particular time. So historically we received a whole variety of types of shipments and vans, but primarily most of the waste is received in a cask, which would have what we call high integrity containers inside, which ultimately are placed into disposal. So the shipment is received, moved to a location for a controlled location for preparation. And that controlled location is in the restricted licensed area of the disposal site. So the vehicle that's received and then the cask are prepared and then moved out to the disposal area and specific location for disposal. Most shipments are offloaded by crane, overhead lift, and placed into those concrete disposal vaults that are already staged at their disposal locations. During that evolution of disposal, you'll have radiological control personnel as well as operational personnel controlling the operation. Placed into disposal inside the concrete lid is placed, and earthen materials are pushed out over in an interim fashion over the disposed area as the waste is placed into containment. And then the empty shipment, cask, and truck are then released through radiological processes and dispatched out over the highway again. So in a nutshell, that's the standard routine, receipt, disposal, and release.
Understood. Thank you for sharing that with me. That's a great answer. So essentially, the radioactive waste is dumped into the ground.
Well, it is in any waste we receive has to be contained. Some facilities can receive bulk waste that is can be pushed into the ground or dumped into the ground, but these have to be in all cases contained with minimum liquid. So they're supposed to be dry, so they're contained, and they're dry waste and placed into concrete.
And so this site, this 235 acres, will once it's filled, will it just be a restricted area?
So
into perpetuity?
It will remain a restricted area throughout operations, and then when operations end, there's a decommissioning period, which is projected to be 1 to 2 years at this particular time. After that, there is a post-closure observation period, which Chem-Nuclear Systems is still involved in the observation to ensure that performance objectives of the license are being met and expected to be met into the future. That period is estimated at about 5 years. And at the end of that period comes to an end when the license is transferred to, back to the agency or back to the state of South Carolina.
Is that DHEC or ORS?
That would be ORS having actual, my understanding would have the actual responsibility to hire an agency to oversee it during the institutional period. So the institutional period starts at that point for management and maintenance of that. And what we do with that 235 acre, what is done with that 235 acre property during that time is there's a range of potential things that that could be appropriate, or it may be appropriate simply for a certain amount of time to simply maintain and monitor. So that is to be determined.
Understood. What do you know the range of options? Could you tell us a few of those options? It's really somewhat speculation, but the area actually and locally and adjacent to it is pretty good wildlife habitat. Immediately adjacent to our property, or actually on our property, is a state heritage preserve conservation easement.
There are Carolina Bays immediately north of our property. Our large water management areas are kind of forming into wetland areas that ultimately, it could be simply natural area supporting adjacent properties. It could be used as grazing or other types of things. Again, the hazard on the surface is very minimal. Post closure, there would need to be restrictions on the ability to install penetrations into these areas, obviously, for an extended period of time.
Okay, that makes sense. Thank you for sharing that. So how long away are we from the facility closing?
So we are supporting the Atlantic Compact under the Atlantic Compact Act, South Carolina. And we basically serve at the discretion of the customers, the Atlantic Compact. Our capacity that we have currently and the rates at which we receive volume, it could go on quite a while. We make a basic assumption of around 30 more years, but that could go longer based on the volumes we receive at this time. But again, we work in an economic environment where our customers could find better options in the future. So that's somewhat out of our control. The longevity is dependent on multiple factors.
Understood. This operation has been going on since about 1977?
1971.
1971. So if it goes on for 30 more years, we're getting close to 100 years of radioactive waste underground. Are you concerned
Correct.
about any type of contamination, exposure, pollution? In your hypothetical, when you talked about the facility or the land being used for grazing, will that grass have any contamination in it?
Would not be expected to. It's one of the things that we would analyze. So, the primary pathway is groundwater.
Have you had any contamination or spills as it relates to groundwater?
Yes, we have. So I can give you the estimated date, but as early as the late 1970s, a plume which primarily composed of tritium was identified from early operations. And that plume has been in existence since that time. And as I alluded to earlier about mitigation activities, since about 1990, there's been a significant effort to upgrade the containment of the existing disposal area. And through the history of operations of the site and regulatory environment, there have been quite a few changes in the nature of what can be, how waste is managed and handled to improve the situation regarding the kind of, the waste that we receive. So that plume continues to exist. We continue, but we also are compliant at our compliance point. And DHEC makes an annual report of the status of this groundwater contamination. So, as a public report.
How often is that public report made available?
The South Carolina DHEC has been making an annual report. So I don't know if it was affected in the last year or so, but my understanding is they report annually to the public on the status of the South Carolina or the Chem-Nuclear Systems Barnwell facility plume.
When was the last time you read that report? Like, is that something that's filed or on file, I should say, at Chem-Nuclear? Is that something you all review?
Yeah, I've probably looked at it within the last few months for other reasons. So, I mean, it's readily available. Something that that DHEC produces based on the information that we provide in our reporting and their split sampling with our operation.
You have access to it, though, right?
Oh, yes.
I'm going to
Yeah.
ask for a late file
I mean,
exhibit. Attorney
yes, I
Black,
can
would you-
provide that.
Would your client mind providing a late file exhibit for that DHEC report?
We'd be more than happy to accommodate the commission and file a late filed exhibit on that report.
We will observe Exhibit 3 for that late filed exhibit. So, will the plume ever resolve, sir? Or is this something that is here to stay?
Well, the recent history of the plume has seen significant decreases in the primary constituent being tritium. Tritium has a 12.3-year half-life. So rule of thumb is that 10 half-lives or so, basically the original material becomes, is decayed away in the case of tritium. So you have a time frame for the existence of the various components within the plume. So you have to look at all the various aspects. So it's, the primary component tritium will continue to, over time decrease in overall quantity due to decay, and then simply original washout from the facility. This plume will be around for an extended period of time because there are minor amounts of other kinds of components that exist in there. So, I mean, I couldn't give you as of this date, it will be, a undisturbed groundwater area.
Has DHEC identified or has Chem-Nuclear identified who or I guess you could say what could possibly be at risk, health risk as a result of the plume? Human, animals, any health issues possible there?
Yeah, based on our compliance with the regulatory requirements, the answer would be no. The plume, as it stands underground plume here at the site, extends under property, either that is state-owned property or Chem-Nuclear Systems property that has a state deed restriction on the property for access to that water. And at the end of that pathway, it discharges into a creek, which flows onto the Savannah Riverside. And the compliance point is in the creek.
Does the public have access to that creek?
The public does not have access to the creek I believe it transfers directly onto Savannah Riverside property or DOE property. Down in that area, it becomes kind of marshy and large area of wetland. And there are properties immediately south that are in proximity, but it's not our belief that they have access.
Have you had any issues with your employees' health, cancer, any other illnesses that could be attributed to the radioactive waste?
We haven't made any connection between or any trends in employee health relative to contamination at the site.
What is the plan if some catastrophic event were to occur? 1,000-year flood, weather event, earthquake. Is there any more danger to contamination or spillage if something like that were to occur, or is the risk the same whether
Yes, given that the materials are in the ground, in containment, the risk of and also our location outside of significant, we're on a high area, kind of a groundwater divide and elevation divide area. So from a flood standpoint, from an earthquake, you know, you might damage the cover potentially in an earthquake scenario or but nothing that would catastrophically endanger the public in an immediate sense or an acute way. Since when these materials are in the ground, there's not much scenarios you can see where that becomes your issue during extreme weather event.
All right, sir. Thank you very much for answering my questions. I greatly appreciate it.
Thank you.
Any more questions for this witness?
Mr. Chairman, this is Delton Powers.
Commissioner Powers, you have the floor, sir.
Thank you, Mr. Chairman. Mrs. Smith, good morning, and
Good morning.
I guess happy Earth Day.
Thanks.
Just following up on what the chairman has brought up about employees. And also, there's some concern about local residents or residents downstream. Is there any sort of medical or testing facility either on site for employees or nearby residents for testing to exposure provided by Chem-Nuclear, provided by DHEC, any sort of medical facilities on site?
Well, we don't have a medical facility per se. We have a laboratory where you can check any personnel are regularly checked for any radioactivity that may have entered their body for some reason. So contamination of personnel is an important concern, and it's not something that we see, but we have the facilities to do that both for ourselves and the public if it was felt necessary.
Okay. And when you're talking about tritium, and I guess your math, which I try to do in my head on your half-life, we're talking about 120 years when you say 10 half-lives?
Yeah.
30 years?
Correct. And so and we've been operating, and a lot of that has gone into the ground. Over the last, we're already, 50 years in some cases, in the early days. So, and the higher volume era, if you reflect now that we receive on average, let's say around of the standard routine waste of around 10,000 cubic feet a year. At our peak periods, we were receiving 2 million cubic feet a year. So.
But when we think about 120 years, it's projected Chem-Nuclear will not be in business at that time, or what protections are there once, let's say you went out of business?
So, we have an obligation to the license, and we also have the long extended maintenance care fund, which stands at 152 million at this time. So, some of the protections are about, this facility has been contributing through its customers, a significant fund for, long-term maintenance of the facility and monitoring, as well as if there need be other kind of actions.
Well, I guess what I'm trying to ask, who would be doing that monitoring in the future under the scenario that Chem-Nuclear was not in business?
Well, we would have to release ourselves from the license. There is an obligation to do that, but if we didn't exist, then ultimately it's on state property. And ultimately after transfer of that property, it goes to the state's, the manager that they would hire to run the site using that funding.
Okay. I've tried to read the graphs. Some of the things seem all over the place. One thing that's not mentioned, and maybe it's just semantics for me, from my experience with coastal issues, there's no mention, talk about groundwater, but there's no talk about stormwater runoff. With the crazy weather we're having and the massive storms, is stormwater an issue, above and beyond the groundwater issue?
Well, stormwater is a management issue, given that you need to operate for closed trenches. Stormwater simply is not a significant concern. We operate below grade, so when you get heavy rainfall, you've got to manage that water, test and manage the water. But the contamination through stormwater pathways is, under our current controls, is not expected to be a concern.
Okay. Well, the recent Supreme Court case a couple of years ago, I think there was a finding that Chem-Nuclear violated the state rules to prevent rainfall from getting in these trenches, which is what I call stormwater runoff. What was the problem? What was the problem with the trench or the design of the trench that led to these runoff issues?
So the disposal trenches at the Barnwell Disposal Facility are open excavations. The waste is placed into concrete containers and then closed immediately at that point in time and covered with earth. Now, the issue that is raised is that there were other additional means to prevent water from flowing or contacting waste. That the crux of the issue was simply design aspects to maximize, I guess, prevention of water intrusion. So ultimately the end of that lawsuit process led to only a standing of one particular issue of which we've responded. So we have contended all along that we've had the engineering controls in place to address the concerns raised through that lawsuit. So as it stands now, we are under current review. We have put our license back in under renewal in 2019, and along with it, addressing the last findings of the current court. And so our contention is that we have met those specific conditions of the regulations. And so I would want to just point out that the issues raised, that from the beginning and in DHEC's analysis, we have been in compliance, because throughout this trial process, we have not had a non-compliance or an NOV with license or regulations from our regulator for how we operate.
I understand your position is that you're in compliance, but based upon your review and based upon the history and problems that occurred, has your company taken any action to mitigate the runoff issues or made changes to address that?
Yes, we have. I mean, we have added additional measures on. There was some concerns raised about vaults being open while they awaited the placement of a actual shipment. We've added temporary covers. We have enhanced our procedures for rapid removal of water to minimize the potential for contact of stormwater with vaults. Let's see the other actions. And then also controls on ensuring that interim backfill is as close as possible to the face of the waste, so that you've got cover, you minimize in the duration and the amount of vaults that are theoretically exposed to stormwater. So, and we've taken a number of actions.
And I think it's roughly $33,000 beyond what was projected to buy vaults. Has there been any, because of the runoff and different problems, is there a change in the design of the vaults? Are the vaults different, better, or how are you sourcing them to know you're getting a sufficient product?
All right, so the vaults have not changed. You know, the lids on the vaults, although they're not designed to exclude moisture, they do serve that function, in fact, and that the lids overlap in such a way that it would be challenging for water to get in there. However, the vaults do and were designed and intended to have a hole in the bottom, which was discussed, and the hole in the bottom was intended that if water were to get in there, it's better for the water to leave than to spend longer contact time inside of the vault in proximity to waste. So the difference in the cost that you observe in the vaults is not because there's a change in their design. You know, it's just the typical variability based on the incoming waste, types of waste that we receive. And so that drives year-to-year changes and that's not also reflecting any significant increase in cost of vaults.
Thank you, Mr. Smith, and thank you, Mr. Chairman. That's all I have.
Any more questions for this witness? Mr. Smith, I have a question for you based on your mentioning of that $150 million fund. I can't remember exactly what it was called. Could you remind me? I don't know if it's a remediation
It's extended care maintenance fund.
Extended care and maintenance. So do you think that is enough money to manage the worst case scenarios at the facility? And obviously we don't know what we don't know, but just in your knowledge and experience, do you think that's enough money?
Well, again, there are potentially scenarios that can be very expensive. Our anticipated expected scenarios based on the performance we're seeing is that is adequate. We make an evaluation of this fund as part of our decommissioning evaluations, and that most recently in 2019. And the ORS has the responsibility to assess the fund's adequacy. And they have hired third parties in the past to look at it. And as my understanding, as we speak, they're looking at making a new assessment of that adequacy of that fund.
Outstanding. And obviously you understand the commission's concern that the state does not get left holding the bag, if you will, for environmental outcomes that were possibly foreseeable, that were not addressed, and $150 million or however much it would be at the time would be a drop in the bucket, and it would more than likely be on the state if under those assumptions. Is that not right?
Yeah, there is some, I see shared responsibility, but I guess there are scenarios that have been raised that that the state does have a role, yes. And part of that is recognized by the states, as I mentioned, the ORS's involvement and responsibility to make it, to be part of that assessment. So there's, it's not simply us making that conclusion of adequacy.
Right. Understood. But it's your testimony today that the state, from your experience in Chem-Nuclear, they're doing everything in their power to prevent any type of catastrophic environmental event.
Yes.
Thank you, sir. Are there any further questions for this witness?
Mr. Chairman.
Commissioner Urban.
Thank you, sir. Mr. Smith, how are you, sir?
I'm good, thank you.
Good. What's the name of the freshwater aquifer where the plume is located?
So the plume here is there's a formation. They have a couple of names that have been applied over the years, but there's a Barnwell Formation under the site. That is, about 90 to 100 feet down is the first kind of potential aquifer location at this site. There's a deeper Middendorf, which is quite deep, that has above that layer is a kind of confining layer for that. So we don't see within our models any potential for impact on that. So the general pathway is fairly shallow. A vertical movement from the site area down to 80 to 100 feet, and then generally horizontal, moving in that first sandier aquifer zone until it reaches a discharge location at nearby creek.
Aren't there cities and utilities downstream that draw from the freshwater aquifer, their drinking water sources?
No, I mean, this plume is very well defined. It extends over a distance in the groundwater of about 3,000 feet. It moves southwest of our location, which is located immediately adjacent to the Savannah River site. And so we're well away from the Barnwell City locations and other, so that the definition of the plume is quite wet and is quite well defined and restricted on where it's located.
At one point in time, wasn't there some research done that would allow possibly for some kind of pumping of the plume and trying to extract the nuclear material?
Yes. So there is oh, good. So, sorry, Aaron.
I was going to ask you, what happened to that plan?
That plan still exists. It's a contingency plan that's been in place for a long time. Looked at that plan looked at a pump and treat scenario, which would be installed if found necessary, most effectively near the headwaters of the creek location, where it's most shallow to access the groundwater and most concentrated to be able to intercept and remove. So that was established with compliance levels, concentration levels to trigger different steps to make the analysis of implementing the system. Those levels haven't been nearly reached, or not anywhere near, but the plan exists and continues to exist.
If they were reached, the trigger levels were reached, do you have a cost estimate on what it would take to pump out the plume and properly treat it and dispose of it?
Yeah, so the approach proposed is a pump and treat, which would involve a boiler system to disperse tritium into the air. So there wouldn't be a disposal aspect. It's not the only method that's out there, but that's the method that is identified in that contingency plan. As an example, another alternate approach is a pump and recharge option, where you could pump and then place it back in that pathway and take advantage of decay over time in that way. So, that particular methodology is, I would need to, I don't want to put a number on the record that is incorrect, but we have historical numbers that are in the range of the $40 million range. But I'd like to, put an asterisk on that for record, that I would need to give you some reference more up-to-date information, or at least make provide something that would be more accurate than me telling you right now.
Because I'm sure over time, there's an inflation factor, just to the material costs, labor, site prep, so forth and so on, right?
Yes, and we've looked at that recently. I just don't recall the exact figure.
Has the Office of Regulatory Staff included that particular cost? Did you say 40 million?
Yeah, and that's what I'm recollecting. It's a range is my recollection, depending on, much lower end number for treating to meet compliance or treating to try to remove everything that's passing by. So it's
Is
range of numbers.
Is that figure included in the $150 million fund or not?
It, I don't know if that figure is in their previous analysis or not. I know that it's recognized in the most recent ORS analysis that cost amount is identified. Whether how they incorporated that and the relevance of it is when you do it in the timing. So I'd like to. There is a public report the ORS has prepared that speaks to contingency actions, including pump and treat. So,
is that document public? Is it available to us?
I believe it is.
Can we make that a late file exhibit, please, Mr. Chairman?
Yes, we can. We will reserve Exhibit 4 for that ORS report as a late filed exhibit.
Because my concern, yeah, go ahead. I'm sorry.
Well, I just want to have a clarification on that because they looked at a whole range of potential remediation options beyond what we have proposed and including what we've proposed. And there are some options in there that are very expensive, which are basically hydrogen separation technologies, which are not something that are reflected in normal action. So I want to, for the record, be aware that they include numbers that would be comparable to ours and other techniques that are even more expensive.
Yeah, so I'm sure you're familiar with the recent Westinghouse debacle that we dealt with at the Public Service Commission, where the taxpayers or the ratepayers were left kind of holding the bag for a very large sum of money when Westinghouse went bankrupt. And I'm not suggesting that Chem-Nuclear would ever go bankrupt, but it's one of those contingencies that has to be planned for as responsible regulators. So I'd like to ask the Office of Regulatory Staff to update the information so that we get a better handle on what we're looking at. Because as you know, the cost could be higher depending on when the trigger is pulled, if and when it's pulled or reached, to clean up that plume. And we just want to be prepared as best we can. We don't have a crystal ball, but we'd like to be reasonable and prudent in our projections so that we have a fallback fund, which would at least be a buffer to a catastrophic event. You understand?
Yes.
And so, as part of our order, I'd like to include that request that the Office of Regulatory Staff examine this issue so that we, make sure that we have sufficient funds in the unlikely event that a catastrophic incident occurred, like an earthquake or something similar that could put us in a position to have to take dramatic and immediate emergency mitigation measures to capture the tritium. Just want to make sure we have that covered. Thank you, sir, for your testimony today.
Thank you.
Mr. Smith, I need to clarify something for the record. That ORS report that you're referencing, do you have access to that report?
Yeah, one way, I mean, I have access to the report. I believe it's a public document.
Okay, I just wanted to make sure you could actually file it as a late filed exhibit.
Yeah, one way or another, I can get that document, yes. And I think it's like a 2008 era, I believe, the most recent one. So.
Okay. All right, thank you, sir. If there are no further questions, well, any redirect, Attorney Black?
No redirect, thank you.
All right, Mr. Smith, you can step down from the witness stand. Applicant, please call your next witness.
That is all we have today, Mr. Chairman.
All right, the applicant rests. ORS, please call your first witness.
Thank you, Mr. Chairman. This is Chris Huber for ORS. As I mentioned previously, we did not pre-file testimony, but Mr. Sullivan is in the room with us if there are commissioner questions.
Yes, let's speak to Mr. Sullivan. And Attorney Huber, I don't know if there's an issue with your microphone, but we're having a hard time hearing you in the commission room, sir.
Okay. Bear with us just a few minutes while we switch our audio. We've got to put headsets on for the witness.
All right.
Thank you, Mr. Chairman. I believe we are ready to go.
All right, Madam Court Reporter, if you would swear the witness.
Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
No, I do not. Should I hit the?
Oh, yeah.
No, I don't hear anything.
Okay. Wow.
So, sorry, Mr. Chairman, we're having technical difficulties. We'd appreciate you bearing with us just for a moment.
No. I hear it now.
Thank you, Mr. Chairman. I believe Mr. Sullivan can hear the commission now. It may be best for the court reporter to go through the swearing in again. I do not believe he could hear her previously.
Mr. Sullivan, please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Sullivan, would you please give your full name?
My name is Daniel F. Sullivan.
By whom are you employed and in what position?
I'm employed by the South Carolina Office of Regulatory Staff. I'm the director of the audit department.
Are you the same Daniel Sullivan who prepared a 2-page report in Exhibits 1 and 2, which were filed with the commission in the docket on March 16th, 2021?
Yes, I am.
Mr. Sullivan, please answer any questions from the commissioners.
Sure.
Good morning, Mr. Sullivan.
Good morning.
Mr. Sullivan, I've seen you testify several times, and I know that you're an honorable man, and I want to make sure we protect your reputation as such. I don't think you heard the court reporter swearing you in initially, and in a blooper moment after she said the oath, your response, an unknowing response, probably to another question, was, "No, I do not." And it made it appear as if your answer to the oath was, "No, I do not intend to tell the truth." So just in case anyone out there in the live stream world saw that, That was a technical difficulty. Mr. Sullivan did not hear the initial oath. Is that correct?
Yes, sir. Yes, sir. That would be correct. I think when I said no, I do not, I was referring to the fact that I could not hear.
Yes, sir. I believe that was the case. And it's amazing that the timing on that was perfect. As such, it seemed as if you were confirming that you did not intend to tell the truth, which is definitely not the case.
No, sir, it is not.
Mr. Sullivan, I have a few questions for you. The general theme of my line of questioning is regarding not having South Carolina hold the bag for some miscalculation, some mistake or oversight for a foreseeable environmental event that could happen at the facility. I understand that Chem-Nuclear is in compliance with regulations, and they've worked with you all to make sure their expenses are in check, and that's fine. But I wonder whether or not there needs to be other economic mechanisms or maybe even increased the price or the what they charge to receive that waste from others. If there needs to be some revenue stream to make sure that there's enough money in reserve to address any catastrophic environmental event 100 years from now.
Yes, sir. And what I can tell you about this subject is that ORS is the administrators of the Extended Care Maintenance Fund. We are currently in the process of procuring a consultant or a company to determine the sufficiency of the fund. And I've heard through this hearing items brought up such as a catastrophic event, Commissioner Irwin referencing if the plume had to be treated. I would imagine that whatever company or consultant is hired to determine the amount in the fund, I would imagine they will take all these items into consideration when they give their opinion on the sufficiency of the fund.
Understood. And is this company, is it purely a financial company or is it an environmental company? Like what are they using to determine whether or not the funds are sufficient?
I'm not really sure what the expertise of the company is. I would imagine it would have to be somewhat financial and somewhat environmental, considering this is not something that is disposal of nuclear or not nuclear, radioactive waste is not something that's typical or common. So I imagine it will have to be a company that has areas of expertise in financial and environmental concerns.
Understood. So do you know if there's a path forward if that company returns a result that says the reserves are underfunded? What would happen if that was a result of the report?
I don't know for sure, but I'll tell you my opinion of what would happen. Obviously, there would be a conversation or a meeting to be had with Chem-Nuclear, also to be had with the Atlantic Compact Commission, the generators of the waste, because ultimately any increase in costs to dispose of waste at the facility will be passed on to the generators of the waste. So I imagine it would be a collaborative, as is done now currently. There's a good working group with the Atlantic Compact Commission, ORS, the generators of the waste, and Chem-Nuclear. I imagine all groups would get together and discuss what the path would need to be going forward to address the inadequacy of the fund if that was what was determined.
Thank you, sir. When do you expect this report to be complete?
I was told that it should be complete within the next couple of years.
All right. Thank you very much, sir. I have no further questions for you. Any questions for Mr. Sullivan?
Mr. Chairman,
Commissioner Urban?
Mr. Sullivan, good to see you today.
Good to see you, Mr. Urban.
One thing that I would be interested in knowing, and perhaps you know, if not, perhaps Chem-Nuclear could tell us, are there companies like Lloyd's of London that would be willing to offer or provide a performance surety bond, which for some certain, so that Chem-Nuclear could pay it an annual premium rather than putting cash in a fund? Is that an option that you're looking at, or is there any company would be willing to assess and assume that kind of liability?
Personally, I'm not sure if, you know, if that is an option. Maybe Mr. Smith with the company would have more information. I do know, obviously, the company does have insurance policy to protect them against, I guess, catastrophic events or some kind of leakage or radiation, or, you know, they have an insurance policy. But is there a company, is there a company out there that would be willing to, for the future? That's a question I don't know the answer to.
I want you to look into it, because my concern is most general liability insurance policies have a number of exclusions. One, you know, you typically see exclusions for acts of war, unforeseen circumstances, nuclear events. I'm betting that there's some kind of exclusion in the policy that probably wouldn't help South Carolina taxpayers. So I think you better look at that as a first step. And then, and see if there's a commercial insurance product out there that would be willing to give a quote that does not have such an exclusion. And if so, examine the cost of a premium. And in that event, if nobody's willing to insure that risk, perhaps Lloyd's of London is very creative in creating a product like this, where the risks are high, but, you know, the contingencies are low. And they might be willing to write a specially designed policy with an exclusion where, you know, let's say the first $250,000 would have to be paid by Chem-Nuclear, and then anything thereafter would have to be paid by Lloyd's of London. That kind of gives us a backup buffer, because these kinds of, I know I read recently where we had a gasoline spill up in Anderson County near the tank farm, and several 100,000 gallon spill, and the cost estimate to clean that up, it was just astronomical. I don't remember the exact number, but, you know, the costs are high, and I don't think $150 million would touch it. I think the witness has been candid that probably wouldn't touch it. So we need to make a plan. We need to come up with a plan of action. If Lloyd's of London can't write that policy, then I think you're going to have to take a serious look at the size of the fund and incrementally increase it over time, at least to cover inflation, because, you know, everything costs more now. The other option you might want to do is contact the U.S. Department of Energy and see if they have federal funds that could be used as kind of a backup in the event of a catastrophic event. I know that it seems like they have something like that for the adjoining nuclear plant. And of course, this is on state property, so you'd have to work out an agreement. But I would contact our congressional delegation and see if they can make an inquiry as to whether the Department of Energy would have any role to play in planning for this risk. Those would be a starting point, I think, just kind of, and report back to us on your findings. Could you do that?
Yes, sir. So I took some notes, and I'll make sure, or ORS will ensure that we look at the current policy in more detail next year to make sure to look for those exclusions that you mentioned, and we can report back to you on that. I know there's some other folks here at ORS that are watching this hearing today that are more involved in the procurement of the consultant or the firm that's going to perform this analysis of the extended care maintenance fund. So I know that that's something that we can write into the scope of services for that company. It's for them to look and investigate as to whether there's some insurance companies such as Lloyd's of London that would be able to provide some additional coverage. And also maybe reach out to Department of Energy, as you said, to see what additional protections there might be from the Department of Energy.
And Chem-Nuclear might have the corporate assets just to buy a performance bond in some certain amount. Had we done that with Westinghouse, the taxpayers sure would have been a lot better shape. Unfortunately, there was no recourse when Westinghouse went bankrupt and left Santee Cooper and Scana holding the bag for the nuclear debacle. So that's why my thinking is, let's see if we can come up with a plan to prevent another occurrence like that from having a ripple financial disruption of our state economy and our state government.
Yes, sir. Understood.
Thank you, Ms. So. Appreciate it.
Any more questions for Mr. Sullivan? All right. Attorney Black, I think I left you out. Do you have any questions for Mr. Sullivan? Attorney Black?
I do not.
All right, sir. All right. Is there anything else before we adjourn for today? No, we are adjourned.
Nothing from ORS. Thank you.
All right, we are adjourned. Thank you.